Hey guys, in this video, we're going to talk about the notice of intent to deny. What is this notice? Should you be afraid of it? How should you even respond to it? These are the types of questions that people often ask when they get this very important and, of course, sometimes scary notice from the government about their green card case. So in this video, I'm going to break it down for you and give you 5 things or 5 tips that I want you to really hold on to in the event you get this notice of intent to deny. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide and across the globe at McBean Law. Reach out to us at 888-462-4006 to request a meeting with an attorney. Also, friends, we have a terrific newsletter. Subscribe to our free newsletter, the #1 immigration newsletter. Subscribe at mcbeanlaw.com/subscribe. Now, let's talk about the notice of intent to deny. The notice is something that is sent out when the government has a huge problem with your case. And this is in the green card case that I'm referring to. It also happens, by the way, in naturalization cases as well. But in this video, I'm just going to really hone in on the green card process. With this notice of intent to deny, it is usually sent out with very serious allegations. For some people, they're kind of like allegations, right? They're considered allegations. The tone can sound very accusatory. It can make a person feel guilty, like, oh my God, I've done something wrong. The government is accusing me of something. For other people, the tone may not be that strong, but certainly in marriage cases and the cases we've seen at McBean Law, the tone tends to be very, very intimidated and strong. But don't be afraid of it, guys. There is a way to handle it. The notice of intent to deny can be issued in any kind of case, right? Parent to child case, child to parent case, a case between 2 spouses, right? A marriage case. Any type of filing on the green card side can result in a notice of intent to deny. With this notice now, the first thing I want you to keep in mind is this. Who is it addressed to? Who is the person that they want to respond to this notice? This is a very important issue. We see this often at McBean Law, particularly in marriage cases, when one spouse comes to us and says, we're no longer together. I received a notice of intent to deny, but it is addressed to my husband and I want to respond to it. And I'm the spouse beneficiary. I'm the one here applying for the green card. I want to respond to it. And we have to tell people that actually only your husband can respond to this because it's addressed to him. It's about his I-130 petition, not your green card application. So understanding firstly who this is addressed to is really critical because ethically speaking, only that person is allowed to respond to the notice. We've had people say to us that they've worked with lawyers who responded on their behalf for their spouse who they're no longer with. And guys, that lawyers aren't supposed to do that. Be very careful with that. The second issue that I want you to be aware of is the deadline. The deadline for the notice of intent to deny is now 30 days. The flexibility under COVID is over. You do not have more time to respond. It's only 30 days. Thirdly, you have to ask the question, do I even have enough evidence to respond to this? Do I have what it takes to respond within 30 days? And for some people with a very complex case and complex background, they won't have 30 days. They won't have enough time, I should say, to respond to this notice of intent to deny. And so they tend to panic and try to put things together. And sometimes people make up evidence, right? They make up documents and they make up a lease agreement and submit that fraudulent document to the government, not realizing that fraudulent document is getting them in a bigger mess. Don't rush to put evidence together that is not accurate and true. What I want you to keep in mind is whatever evidence you send the government can be used against you down the road. So be very careful with how that evidence is prepared and submitted to the government. If you don't have enough time to respond to the notice within 30 days, they will deny the case because they're expecting something within that 30-day time period. Other times, folks get this notice late. By the time they get it, they only have maybe 15 days to respond, and the government is asking for a lot of information and complex things need to be explained, and there's just not enough time for that. When that happens, friends, for some people, it's best to do a refiling of the case once you have everything all together and you know where the weak spots were with your initial filing, so therefore you could prepare a better case the second time around. But work with an attorney to get that specific type of guidance for your case. Now, the fourth thing I'd like for you to keep in mind, and this is with respect to marriage cases, the notice of intent to deny can be issued after your interview with the government, or after they do a home visit, or after you file. It can be a very early process. For most people, it's not that early. It's somewhere in the middle, right, of waiting several months into it. But for others, it could be very near to the time that you filed the case. So don't be surprised by this. But generally, what we've seen is that it happens after your interview. If you're separated from your spouse, the last address that the government has on file for the case is where they're going to send this notice of intent to deny. So if you're not together anymore and it goes to the petitioner's spouse's house and he's upset with you, he may not tell you, most likely he will not tell you that he's received this notice and that he has a responsibility to respond. That may not happen. And for some people, they don't even know that a notice had been issued, and they find out later when they get a denial letter. So just keep in mind that the petitioner's address on file is where that notice will be sent. And then lastly, guys, how long will it take to hear back from USCIS if you respond to your notice? Well, it really depends. We've seen the government respond within a matter of days, particularly when it's an approval. Okay, if it's an approval, it happens very quickly. Other times, if it's a very complex background, complex case, it could even take them over a year to respond to what you've sent to them. So it really depends on the type of case and what type of evidence they were seeking from you. It could be a few days or it could be more than a year. For most people, I think it's somewhere in the middle. When you get this notice of intent to deny, do not panic. Work with a professional. We work on these notices all the time, but you've got to give your lawyer enough time to work on the case. And for some people, the lawyer may very well say, we don't have enough time. There's not enough time to pull together the memo or the evidence, or you need to get some evidence from Africa or Haiti or somewhere, whatever country you're from. It's going to take a long time to get what you need from your home country. And so when that happens, guys, you may have to make that tough decision to refile your case, a stronger case. Guys, I hope you found this helpful. Comment below. Let me know what you think about it. Share this with other people. And before you leave, don't forget to subscribe not only to our newsletter at mcbeanlaw.com/subscribe, but also subscribe to my channel and hit that notification bell. Thanks so much for watching, and I will see you in the next one. Bye-bye.